morning, everyone, and welcome to the JRG webinar for December. Our topic this month is Avoid the Pitfalls of Plan Administration. We'd like to go ahead and, first of all, before we actually get into the presentation, thank all of those who are participating through our partners, Chamber Choice, PHA, First Commonwealth. We really appreciate the partnerships, and again, thank you for attending today. So our agenda is pretty short. We're trying to get through it quickly as we can in an hour. But again, if you have questions, make sure that you type them in and send them to us because we want them to be addressed. But we're going to talk about recognizing an ERISA plan, plan administrator, who is that person actually, some SPD information. And then at the end, we're going to get real. We want to talk about some actual circumstances. So with that being said, we know that the federal statute is known as ERISA. ERISA stands for the Employee Retirement Income Security Act of 1974, and it's been amended many times since then. However, this statute, it provides the regulatory framework for employee benefit plans. The purpose of ERISA is to protect the interests of employee benefit plan participants, generally your employees, and their beneficiaries, by requiring certain disclosures to them of financial information and other information concerning the plan. Now, it also establishes standards of conduct for people that we call plan fiduciaries, and also it provides for appropriate remedies and access to federal courts. What we mean by remedies is that if a participant feels they've been wronged, they may want to go ahead and sue the plan, and they can get a remedy. The thing we have to remember is that an employee benefit plan basically consists of 4 elements. Under ERISA, it tells us that it is any plan, fund, or program. So basically, if you have a medical plan out there, or a medical program, or dental, or vision, and it has to be established by an employer, or also it's considered an employee organization. So, and what it must do is provide benefits to participants and, again, to their beneficiaries. Now, when we start talking about ERISA, it gets to be very comprehensive. And ERISA actually has 2 factions. It has the health and welfare side, and then it has the retirement side. Now, today's focus is entirely on health and welfare. Retirement plans are much more strictly enforced, and there's more regulations as to what has to be done for them. When we're talking about retirement plans, we're generally referencing 401k, 403b, and those simple plans that employers may go ahead and sponsor. So when we want to see, is our plan subject to ERISA, one of the things that we have to look at, again, going back to the definition under ERISA, is what kind of benefits does it actually have to provide? And the first thing it tells us is it provides for medical. And it's defined very broadly. It encompasses things like major medical, dental, vision, prescription drugs, hospital stays. So that's the first area that we look at, is medical. Does the plan or program that you have provide for medical care? The next aspect we look at is generally sickness. So again, a wide array of benefits. We talk about sickness, accident, and actually death. So we would start looking at to say, okay, does the benefit or program that we have, life insurance, yeah, that provides a benefit in case of a death, and we have AD&D, accidental death and dismemberment. That would come under accident. So when we start looking at our plans, we look to see, are they a plan or program? Have you as an employer established it? And generally, if you're providing it, the answer would be yes to that. And does it protect beneficiaries and participants? So in general, when we look at the law or the statute of ERISA, not only does it tell us who it covers, but it will also tell us who it doesn't cover. So if you are a governmental plan or a church plan out there, the statute go ahead and gives you an exception. So again, government plans and church plans are not subject to ERISA. And also, any plan that is established to go ahead and comply with the state requirement. So when we have our workers' compensation plans out there, we have unemployment. Those are state requirements, so they would not be subject to ERISA. Also, some states have mandatory disability laws. Pennsylvania is not one of them, but if you're out in California, Rhode Island, New Jersey, actually Puerto Rico is one of our territories, is required. They have that under state law, you have to provide for disability. So if it's required by state, then it's not subject to ERISA because it would be considered preempted. And then finally, if you're in a situation where you may have employees who work outside of the country and they're in maybe they're in Great Britain or they're in Europe somewhere working, and you're providing a benefit that is established in that territory, those types of plans are not considered subject to ERISA. So we also have, there are certain employer-provided benefits that are included in the definition of an ERISA employee welfare benefit plan, but then they get to have an exception, and generally the exception comes by because of regulation. So as we look for our list here, you know, it gets to be pretty interesting. ERISA literally says that overtime, if you pay shift premiums, vacation, jury duty, are all benefit plans that are outlined as being subject to ERISA. But again, when the DOL then starts looking and says, you know, this really doesn't make sense, because some of the benefits that are outlined are actually something considered to be what we call a payroll practice. So when someone's paid from overtime, that goes to the payroll because they've turned in a timesheet, you're going to pay them. So it comes through payroll. So these payroll practices will also accept or exempt certain benefits that have been outlined in ERISA. And for a payroll practice to go ahead and accept that benefit, it has to be where an employee receives their compensation for work performed or sometimes not performed, and it's just within their ordinary course of business. So again, an example is overtime or vacation time. The payment has to be normal compensation. It can never be more than 100% of what the employee would normally receive. And the other requirement is that it has to be paid out of the employer's general assets. So you have your bank account there, and when you write your payroll checks or when you write your bills, you have that general asset account. So that's where the payment has to come from. What we're trying to hit upon here is that the benefit cannot be funded. Now, the last one that we want to look at, because this is probably the one that you're most familiar with, and that's sick leave. Many of you will have policies. You have PTO days that an employee can use when they're sick. You have sick days, or you may even have disability programs. So generally, these programs would be subject to ERISA if they are paid through an insurance company. So you have a short-term disability or you have long-term disability, and you have a contract with an insurance carrier such as Unum or Cigna. There, again, since they're not paid out of your general assets, that actually would be considered almost funded, so they would be subject to ERISA. However, as an employer, you may just set up a policy that, well, if you have to be out for some time, let's say 2 or 3 weeks, we'll just go ahead and continue your pay, and that's going to be our disability plan. Now, that kind of plan or policy, again, it's providing for sick leave, that would be considered a payroll practice because, again, you're going to pay out of your general assets on a normal payroll basis to the employee. If you have that type of sick leave or disability program, it is not subject to ERISA, again, because of this exception. So one thing you have to be careful of, there's also a practice known as advice to pay. And advice to pay is where you as an employer say, you know, we want to go ahead and provide some type of disability benefit to our employees, and we just want to pay it with their regular paycheck. But, you know, we're not doctors. We don't know if an employee says, I have to be out of work for so many weeks, whether that's accurate or not. So that can be a situation where you as an employer will go ahead and contract with a vendor or an insurer, and all they will do is say, you give us the information, we make the determination whether the employee is disabled, but then you pay them. So again, an advice to pay. Since the insurance company is not paying, it still would be a payroll practice and it would be accepted from ERISA. So the next area that we want to go ahead and talk about when we're saying, are we recognizing an ERISA plan or not, are these, it's called the Safe Harbor voluntary benefits. And our voluntary benefits, we know that they're generally work-life products. They're products that if someone has to be in the hospital, they may get paid $100 a day. Or if someone breaks a leg, they get $100 because they broke their leg or their child broke their arm. Again, we consider those work-life or quality of life benefits. And we have that famous duck up there, and we have the name of another company, because generally as an employer, that is who you will let come in and talk to your employees about these work-life benefits. Now, for these voluntary benefits, the Department of Labor has told us they will not be subject to ERISA as long as you meet these safe harbor criteria. And the first thing is that there can be no employer or no employee organization contribution. So what that means is that it must be completely paid by the employee. Also, participation has to be completely voluntary. So you can't say to an employee, you have a great voluntary plan and you better sign up for it, because that would be mandatory. Also, the employer cannot receive any type of consideration except maybe an administrative cost. And the key issue is, what the DOL considers is there can be no employer endorsement. So what you can do is you can publicize it. Yes, these vendors will be here today to talk to you. Have a great time talking to them. You can collect the premiums, and then you can remit the premiums to the insurer, and you would still be within your safe harbor requirements. So what does the DOL look at as endorsement? They say that you can't have expressed positive normative judgment. This is a great voluntary benefit. You would really not be making a wise decision if you didn't go in there. That's a judgment call there. You can't urge or encourage them. Yes, you should go in here if you want to have money if something happens. And again, and also you don't want to make it a part of, put it on your letterhead and say, this is a part of our stellar benefit program, because that's basically an endorsement. Now, the key area that we want to address with these voluntary programs and safe harbors is that many times what an employer will do is they will say, we have these great benefits, and you can go ahead and pay for them on a pre-tax basis through our cafeteria plan. And this is where employers will fall through the cracks. They'll fall into that pitfall of recognizing a ERISA plan, because the one thing you have to remember, when an employee does something pre-tax through your cafeteria plan, that is considered an endorsement. Again, it's the employer plan. And the other way that it is considered by both the DOL and the Internal Revenue Service is that when employees make contributions through an cafeteria plan, those contributions are deemed employer contributions. So what happens is we go back to our first bullet point and we actually violate that requirement. Because if the contributions are done on a pre-tax basis through an employer cafeteria plan, those are deemed employer contributions. So again, you've got to watch for that pitfall. You can have voluntary benefits and you can either have them be subject to ERISA, or because of your actions, you've actually brought them under the guide or the view of ERISA. So these pitfalls, and we talk about not recognizing this ERISA plan. Let's talk about an employee assistance program. We need to think about that for a second. Remember, under our definition, an ERISA plan can provide for medical care. So what about your EAP? Is it just a referral system? Does someone on the line say, I'm going to give you a list of doctors, you can call anybody you want to? That's referral. That's not giving you medical care. However, if someone answers the line, answers the phone when the employee calls in and says, let's talk about this. I think you may need a prescription. I think we need to delve into this a little bit further. Then they are providing medical advice, medical guidance, that's medical care. And what the Department of Labor has told us is any EAP that provides for medical care would be subject to ERISA. Another area that we sometimes overlook as employers and fall into a big pitfall are our flexible spending accounts, the health flexible spending accounts, and our health reimbursement arrangements. Both of these are plans that provide for medical care. An employee goes to the doctor, they have a copay, they get reimbursed from the spending account. They have a deductible. You've set up an HRA that covers that, again, providing medical care. Also, these types of arrangements or accounts are referred to as self-insured plans. So they even have additional requirements under ERISA and under the Internal Revenue Code. And finally, we've just addressed a big pitfall is where the voluntary benefit, you're not meeting those safe harbor requirements. You may be endorsing it, and you may not even realize that you're endorsing it. So you want to go ahead and make sure that if you have voluntary benefits, that you have endorsed them, either by recognizing them as part of your benefit plan or doing it on a pre-tax basis. They need to be in your ERISA plan document. Something else that we're not going to really go into, I don't know if any of you have on-site clinics, but this is another area where it could be an ERISA plan because it provides for medical care. So the next area that we want to talk about is one that I find extremely interesting. And that's when we start talking about the plan administrator. Now, when considering compliance with ERISA, most of the responsibility and liability are imposed on the plan administrator. So basically, we're saying, well, who exactly is that? Now, the plan administrator is the person or entity that is specifically designated in the plan document. It's outlined. It says the plan administrator is X. However, if there is no such designation in the plan, or if you don't have a plan document, then the administrator defaults to the plan sponsor. And we know that in a single employer plan, that plan sponsor is always the employer. So technically, the plan administrator responsibility falls to the employer. And as well as the plan document, this information also must be identified, or the plan administrator must be identified in the summary plan description. Now, we know that the plan administrator generally has 4 main obligations under ERISA. And all ERISA health and welfare plans have a disclosure requirement, but not necessarily what we can consider a reporting requirement. And the disclosure, when we talk about that, the first thing is that you are required to have a plan document. The plan document basically establishes your plan because you go ahead and you have it recognized by whoever can legally bind the employer. The plan document doesn't actually have to be provided to plan participants. However, it has to be available for review if they ask to see it. And if they do ask for it, you do have to provide it. The next disclosure document that we want to talk about is called that summary plan description and also summary of material modifications. We're going to go into the SPD a little bit further in 2 slides or so. But just as general information, the SPD is a document you do provide to your participants, and it lets them know about the terms of the plan, who's eligible to participate, how much will it cost them, what benefits being provided. But in talking about pitfalls, the one thing that I see that employers really either aren't aware of or don't want to recognize is that the plan administrator responsibility, again, falls to the employer. It is not the insurer who's responsible, especially for providing the SPD, even though the insurer will give you a certificate of coverage or a benefit booklet. We're going to see those aren't SPDs. And it's also not the insurance broker who's responsible for providing these documents to you. It solely lies upon the employer's shoulders. Some other disclosure documents we're going to talk about more in a couple of slides, but want to mention here the summary of benefits and coverage. We know that the Affordable Care Act amended ERISA and put this other requirement in there. We talk about group health plan mandate notices. These are notices that have to be disclosed to the plan participants, and many of them are annually or at certain times during the year. Now, the next item we want to talk about is called the reporting requirement, and that's your Form 5500. And I put the little caveat, if required, because for a health and welfare plan, you're not responsible for a Form 5500 unless you have 100 or more participants as of the first day of your plan year. So if you have less than 100, you don't have to worry about the 5500. However, if you have 100 or more, you do have that filing requirement. For those of you who've heard me speak in the past, I've also brought to your attention, the DOL is looking at that Form 5500 requirement. They would like to change it such that any health and welfare plan has to do a 5500. Even if you only covered one employee on your plan, you would be responsible for that filing. We're closely watching that because, again, proposed regulations have come out on that, and if it would be effective, it would be looking at the 2019 plan year, and that's not that far away anymore. Something else that we also want to mention about is we were talking about the SPD and who's required to provide that. With the SPD, again, it falls on the plan administrator, and this is true even where another party prepares it or distributes it, or if you have a contractual obligation. So if there is a complaint by a participant saying, hey, I didn't get my SPD, it is still going to fall back to the plan administrator. Another responsibility is being a fiduciary. An employer is automatically a fiduciary under an ERISA plan. And actually a fiduciary has 4 or 5 duties, but I just want to go ahead and address the main one here, and that is, as a fiduciary, you are required to govern the plan according to its terms. And what that means is, if you create a plan and if you say you have to be actively at work to get that benefit, then you can't give the benefit to someone who says, I may be off for 3 weeks or 4 weeks or 3 months here or whatever, and you're not subject to either family medical leave where the benefit would still continue. Also remember, don't fall into the pitfall to think that if you have a self-insured plan, your third-party administrator or claims administrator for fully insured is the plan administrator. You would have to have specific language in the contract that addresses that, and generally TPAs won't put that in there. So again, our biggest pitfall is being the plan administrator is that, you know, we unfortunately have this gentleman here who's putting his head in the sand. Either he wants to hide from it or doesn't want to be aware of it. But again, you need to recognize that as the employer, you are the plan administrator. So in our next couple of slides, we're going to go ahead and address what the differences are between a summary plan description, known as the SPD, versus the summary of benefits and coverage, the SBC. So basically, ERISA requires that virtually every employee benefit plan have this summary of plan description. And you're required to go ahead and furnish copies to each individual entitled to receive the SPD. And generally, that's a plan participant. So the Department of Labor, they look at the SPD as being the primary vehicle where you will inform participants and beneficiaries about the plan. As we already noted, you're going to say you're eligible if you work 30 hours a week. Your dependents are eligible, or we will or will not cover spouses. We will include medical and dental and vision, but we're not going to include disabilities. So again, you're telling the participants what their right is going to be. And not only do you tell them about their rights, as the second bullet notes there, but you also tell them about their obligations. So again, obligation would be, you must work so many hours. You may have to pay a portion of the premium. We know that the provision of the SPD is automatic. You as the plan administrator should provide within 90 days of someone becoming eligible for your plan that SPD. When you do create the SPD, it is only required to be distributed actually every 10 years, unless you make some changes. If you make changes to your plan, including simple things like changing a deductible, changing a copay, then you have to give an updated document every 5 years. Now, we didn't go into it, but when you want to go ahead and make a change to your SPD, that's where a document called a summary material modification comes into play. It's a very simple document. It can be as short as a couple paragraphs, but it basically says to the participant, we're amending the plan. We're making a change, and this is how we're making the change. We're changing the deductible. We're taking away this benefit. We're adding this benefit. And as long as you give out these SMMs to your participants, then you can wait, again, 5 years to give out a whole new SPD. It's much easier to give out 1 or 2 pages than maybe giving out 50 or 60 pages of a new booklet. We do know, and the Department of Labor has told us, and they enforce it, that if you actually don't provide the SPD, there's no penalty. But where the penalty will come into play is when the participant comes back to you and says, I'd like to have the SPD. And if you don't provide that within 30 days, then the participant can actually sue the plan for up to $110 a day. Also, the point is made is that if you would come under a DOL investigation and the DOL sees that you're not providing the SPD, the DOL has the right to enforce that requirement on behalf of the participants. So basically, they could enforce that penalty in that manner. So the next document we want to go ahead and look at is the SBC. Now, we know healthcare reform expanded ERISA's disclosure requirements by requiring that a summary of benefits and coverage be provided to applicants and enrollees before enrollment or re-enrollment in their plan. And again, this document, we keep calling it the SBC. This is required in addition to the SPD. I know that many brokers refer to the SBC as the mini SPD, and I think that's very misleading to use that term because employers then begin to think, oh, well, I'm giving out the SBC, which is a mini SPD, so I've met my requirement, and that's really far from the truth. So the SBC, what it is required to do, it has to accurately describe the benefits and coverage under the plan or coverage that the participant can go into. So for example, you have an employee who they were hired a month ago and now they're going to become eligible for the plan. And you offer a PPO and a POS and a high deductible health plan. Since that employee may be eligible for all 3 benefits, you must give the SBC for all 3 benefits. However, maybe you have the 3 benefits, but this employee is in a class and they're only eligible for the high deductible health plan. You would only then have to give the high deductible health plan SBC out. So they do have to be provided in a prescribed form. The DOL says you have to create it in this manner. It has to include this information. And one of the things that you have to include is this uniform glossary of terms. You define what a deductible is, what co-payment is, what co-insurance. And then also you have to give examples. They literally give examples that, now one of the examples is pregnancy. If you are pregnant and you are hospitalized to give birth, this is the benefit that you would receive. Now, as to who has to provide the SBC, if you are a self-insured plan, then you as the plan administrator are responsible, solely responsible for providing the SBC. Slip there. However, if you are fully insured, then there's a joint responsibility between the insurer and the employer as the plan administrator to make sure the SBC is distributed to participants. So how that joint liability comes into play is that the insurer has to make available the SBC to the employer, and then you have to make sure that participants receive it. Now, the failure to provide this document, it can be extremely hefty. It's up to $1,105 per failure. So if you have 10 employees that you didn't provide the SBC for, right away we're looking at that's over $10,000 or about $11,000 in a penalty that could be imposed upon you. So some of the pitfalls. I would say that the biggest pitfall I see is that an employer who's not providing either document, either an SPD or an SBC, to non-employees, to non-employee participants. And those would be your COBRA qualified beneficiary. Maybe someone who was on your plan because they were a spouse covered under an employee and they're no longer there. But they're still covered under COBRA, they'll also have to receive these documents. What about you may have an unfortunate situation where you have an employee who's been incapacitated. And even if you provide that document, they're not going to understand what that document says. You need to provide their guardian or their representative the document. If you have a QMSCO, which is a qualified medical child support order, you must provide the SPD and the SBC to the alternate recipient under that QMSCO. Another pitfall, we've mentioned it several times, where you as an employer or plan administrator, you think that the benefit booklet or the certificate of coverage is the SPD. And we're actually going to talk about a case here a little bit further about that. You're not keeping your documents updated. And this is key because I do want to go ahead and remind you that the SBC was updated and was effective as of April 1st, 2017. So if you have a calendar plan year, starts in January, this is the first time you would be giving out the new and improved SBC. The next area we want to go ahead and start talking about are notice requirements. And there are a myriad of them. There are many more than I like to think about, I guess. The first thing we want to talk, we specifically mentioned ERISA. Now, the next few laws that we may be discussing, they have been incorporated into ERISA. So they are laws in and of themselves. They're mentioned in the Internal Revenue Code. They have their own code sections, but still they do come under some of the ERISA requirements. So I just want to make you aware of that. And the first one we want to talk about is COBRA. And COBRA, this has been so interesting to me because it seems like we haven't had a lot of changes to COBRA, I'd say in the last 5 to 7 years. But around 5 or 7 years ago, it was like all of a sudden, the DOL said, you have all of these notice requirements that you need to be made aware of and you need to be following. Sometimes I'll talk to an employer and they'll say, yeah, so when an employee leaves, I give them their election notice, I make sure they get it. And you start asking about, well, what about when they first came onto the plan? Did you give them their initial notice? Well, no, didn't know I had to do that. And what about if you have a participant who they're no longer eligible for COBRA for some reason? We have notices of unavailability, notice of early termination. And another one that you really need to be aware of is the premium increase. Remember, when you have COBRA participants, you must notify them 30 days or as soon as possible when you know that their premium is going up. Another law out there, HIPAA, the Health Insurance Portability and Accountability Act. We know that there are different aspects of HIPAA. And one aspect of HIPAA is called the portability and special enrollment rights. So we do have a notice. You need to tell your employees that if they are going to waive your group health plan coverage, because they have other coverage, maybe they have a second job where they have coverage, or they're covered under a spouse's plan, you have to let them know that if they would lose that other coverage, that they would go ahead and be able to come on the plan outside of open enrollment. And that's called their special enrollment right. They also have special enrollment rights, such as when they gain a dependent. They weren't married before, and now they are. They can come on the plan. Or the dependent is a newborn, or someone who's newly adopted. And also when someone exhausts COBRA is another reason to go ahead and have a special enrollment right. Our notice of privacy practices comes under, again, the privacy rules. And that's generally for self-insured plans, which remember, if you have an HRA or a health flexible spending account, it's a self-insured plan, and you must follow the HIPAA privacy rules for that. The group health plan mandates, again, incorporated into ERISA. And there are a lot of laws here. We talk about Women's Health and Cancer Rights Act, Newborns and Mothers Health Protection Act, Michelle's Law, Qualified Medical Child Support Order requirements. We have something called patient protection rights that we have to give notifications on. We have something called the CHIPRA notice. We have Medicare Part D notices. So again, these are all requirements and they are all notices. Some of them are annual notices. Some are only required when someone first becomes eligible. However, the key is that the notices must be timely and they must be accurate. So try not to fall into the pitfall of, first of all, not knowing about all of these notices. A big pitfall as to COBRA, not realizing what plans are subject to COBRA. We've already mentioned FSAs, health reimbursement arrangements. They provide for medical care. So they would not only be subject to ERISA, but subject to COBRA. Your EAP, did you think about that one? Is it providing medical care? Our voluntary plans, if we don't meet the safe harbor, then they're subject to ERISA, also subject to COBRA. Dental and vision. I know some employers still think dental and vision are not subject to COBRA. One of the big pitfalls under COBRA, that initial notice that I just briefly mentioned on the other slide, not only does it go to participants, but it also must be provided to a spouse if the spouse is covered under the plan. And I always recommend that you separately send that notice because we know that sometimes employees don't always take everything home to their spouses or to their partners that they're required to. When you delay in providing election notice, if you don't give them promptly, there's a possibility you could be sued. And then inadequately documenting the delivery. Did we send this notice out, that election notice? Did we send that out 2 weeks ago or last week? Geez, don't really remember. Dates can be very important, especially if an employee comes back or ex-employee comes back and wants to sue the plan. Continuing, failing to have reasonable notice procedures. We know that if a qualifying event occurs, and it's a qualifying event that you wouldn't know about, maybe there's a divorce that you don't know about. One of the dependents has aged out of the plan, and you really wouldn't know that. You have to have a notice procedure where those people have to inform you of the plan in order to enforce their COBRA rights. Not enforcing the payment deadline. So many times I will get a question saying, well, you know, I know this person, they're just having a hard time. They haven't found another job yet. And they've told me they're going to be 3 weeks late, but they'll catch up, they'll continue to pay. What you as the administrator and as the employer have to realize, whenever you give these exceptions, you've basically told everybody now then, because you've set a precedent that basically we're not going to enforce the payment deadlines. So you don't really have to pay us within 30 days. Basically, pay us whenever you feel like it. And I don't think that's a position or a pitfall you want to fall into because that can be really hard to administer then. You don't recognize a qualifying event in connection with a leave of absence. Family medical leave, we know it's a qualifying event where there would be a loss of coverage and COBRA kicks in only when family medical leave has been exhausted and the employee does not return. Otherwise, during those 12 possible months, it's not a COBRA qualifying event. Workers' compensation, a reduction in hours, and maybe they lose coverage, or they probably lose coverage because of workers' compensation. And the same with short term. Also, a key pitfall you have to watch, know whether you are subject to federal COBRA or Pennsylvania mini COBRA. Requirement is if you have 20 or more employees, you're subject to federal COBRA. And that's employees, not employees who are on the plan. Pennsylvania mini COBRA is under 20. So from COBRA notices and other notices, we're going to move on to imputed income. And I've always found imputed income interesting because it comes into play in several different areas. Now we know that under the Internal Revenue Code, there are 2 different sections that provide that benefits provided to employees and their dependents would not be subject to taxable income. They're excluded from income. And this would be a case where If you as an employer, you provide coverage for me, but also my spouse and dependents, I don't have to pay any taxes on that. And that's generally, again, for health care. One of the areas of imputed income is where if an employer is paying for domestic partner coverage or for domestic partner children, remember the statute or the code says it's for spouses and dependents. A domestic partner is not a spouse, so an employee cannot receive on a tax-favored basis coverage for domestic partner. It has to be taxed. And we call that imputing the income. We include it in their W-2 and their payroll information, so it can be properly taxed. Another area where this comes into play, and many times it's inadvertent, and I realize that, and this is where you may have an employee who gets divorced, and the court tells the employee, you have to provide coverage for the spouse. So the employee says, well, I'll just keep it on the employer's plan, even though that spouse is now an ex-spouse and shouldn't be covered. So if you discover that, or if that's happening, that coverage that was provided for that ex-spouse needs to be imputed. The value of it needs to be imputed to the employee. Another area that we talk about, and we actually just put an article in our Simply Benefits newsletter I think it was last month, about group term life insurance. If you give group term life insurance that exceeds $50,000, then anything in excess of that first $50,000 has to be recorded as imputed income to the employee. Another section that we're going to hit quickly, cafeteria plans. Cafeteria plans are where you can go ahead and have your employees pay on a pre-tax basis their contributions for health insurance premiums. Cafeteria plans or premium pre-tax falls under the Internal Revenue Service because, remember, they're losing income. So they really watch this practice very carefully. And the first requirement is that you must have a written plan, i.e. a plan document. Just permitting employees to do this on a pre-tax basis without having a plan document is basically invalid, and it could result in taxable income to you and to the employee. Other areas, when you don't have a plan document, you're not following the rules, you may permit employees to come do pre-tax, and they come on and they do pre-tax, and then they stop doing it. That's not permissible. Because remember, an election is irrevocable for 12 months. I do want to get to some of our real life situations, so I'm going to move quickly here. Some miscellaneous, not recognizing a wellness plan. If you as an employer charge an employee a higher premium or premium differential because they are a smoker, that is considered a wellness plan under the Health Insurance and Portability and Accountability Act, HIPAA, and also by the Equal Employment Opportunity Commission. We have certain notices that we have to provide when we have wellness programs. We have to give alternative standards, and we have to watch how we protect that information, especially under HIPAA. And also, really be careful. I talked about it, I call it embedded wellness plan. We know that several of our insurers are now putting wellness programs as part of the group health plan. Even if that's where the wellness program comes from, you still have some notice requirements that you may have to provide to your participants. So let's talk about that's getting real. This first example to me, it's an interesting one. And actually it came out of the Southern District of Texas, and it was finalized in 2015. This was a situation where basically the employer, they had, and the plaintiffs were participating in the group health plan. And what the plaintiffs or the former participants claimed is that the employer did not give them their COBRA notices, their initial right to, as to that they had a right under COBRA, and then when they lost the coverage, they didn't receive election notices. And what they did is they basically sued, and they sued under class action also. So again, this went on for several years, but I think the key thing you want to look at is what's in red. So what the parties were found, the defendant was found to be guilty basically, and they had to pay $1 million back to the participants. And that was, of course, the $1 million did include attorney's fees. So maybe the actual participants didn't get as much as they would have liked to get. But basically, they each received $5,000. So again, just think of this, because they did not provide that initial notice and then the election notice. So another one under Let's Get Real is, here we have it, the plaintiff is Evans, and it's a suit against BAM. And BAM stands for Books A Million. It's basically, it is a national secondhand used bookstore or whatever. And in this case, again, the plaintiff, which was the former employee, claimed the company violated COBRA by failing to provide her with an election notice. She called, she claimed she called them to get one. Company bounced her around a little bit, gave her different employees, gave her different answers or whatever. But ultimately, didn't send out the notice. Now, what I don't note here is that Miss Evans used to be the HR person at Books A Million. And Books A Million also claimed, hey, she knew about COBRA. She was the HR person. We didn't have to send her a notice. That does not fly with the Department of Labor. So keep that, remember that. Just, you can't say, well, the employee knew about it already, so I don't have to send the notice. So after looking at all the facts and circumstances in this case, the court finally said, and I love this quote, they couldn't even find a scintilla of evidence that any notice was ever sent out. And even worse, the company, they really had trouble explaining why this oversight occurred, because they didn't admit saying, we knew she was an HR person. So here again, what they paid, a whopping $83,000 for failing to send that notice to one employee. Basically $38,000. The court didn't give them $110, but they gave the plaintiff $75 per day for every day that the notice wasn't provided. That attorney got $42,000 of it, and then $3,000 covered court costs. Again, one employee. Some other instances, I'm not outlining each case, but this was the holding. This is what the DOL found the employer guilty of and charged them $5,215, inattentive in providing the life insurance plan document and refusing to give the $5,500 when actually they were ordered by the court to do it. $10,220, delay in providing, again, the plan document. $11,550, didn't provide the SPD after the employee gave them written notice that they wanted to receive it. Another requirement for not giving the SPD, over $17,000. So you do see there can be some hefty fines out there. Some more Let's Get Real, and then we'll look to see if we have any questions. This case is interesting. So the employee had a policy that covered himself, his wife, and his children. It was made available through the employer group accident insurance. Participation was voluntary. The employee paid the entire premium through payroll deductions. Now, upon the accidental death of the wife, the employee filed a claim, and then he was only partially paid, so he basically sued. Now, so did we have an ERISA plan here or not an ERISA plan? And I don't expect you to answer me, but this is what I want you to be thinking about. And what the court held here is that they showed the evidence demonstrator the employer endorsed the plan. So that means even though this plan was supposed to be voluntary, paid by the employee, it was still subject to ERISA because the employer did not meet those safe harbor requirements. It gave the employee a booklet with the employer name on it, corporate logo. It explained the employer's plan of group accident insurance. It said each employee can decide, but we ask that you give the program careful consideration and that it's a valuable supplement to your existing coverage. Now, if that is an endorsement, I don't know what is. And also, that's also the court's found too. So again, these are things that you also need to be thinking about. And finally, let's get real before we look at some of your questions. So here we had, there was an open enrollment worksheet, and I don't know if it was prepared by the employer or the insurance broker, but it misstated an employee's life insurance coverage. Now, what the employer did is they noticed they made a mistake, so they sent a revised statement showing the correct lower amount and saying, we made the error, we're sorry. Now, we had, unfortunately, an employee died, and his estate sued for the higher amount. So think about this. Well, what is the problem here? And the problem is that, and I didn't go into all of it here, but basically the employee's estate said, when you gave us this worksheet or this benefit statement, that became part of the summary plan description, so you amended the terms of the plan. So that's why we should have got the higher amount. And what the court said here is, benefit statements or, the summary benefit sheets aren't automatically incorporated into your summary plan description. And why they said that is because the employer here recognized they made a mistake and they took action to correct it. So if this employer had not taken action to correct it, I think there definitely would have been a different outcome. The employee probably would have, the employee's estate probably would have won in this case. But again, think about your actions. If you did make a mistake, do your best to go ahead and correct it and mitigate it. So with that being said, we're going to go ahead and look to see if we have any questions here. Okay, basically we have a question that someone needed to jump off, and they want to know if a recap of this will be sent to the registered participants. Again, you will receive the whole PowerPoint, you will receive a recording, but as to recapping it, again, no, I'm not going to be recapping any further information. So do we have any other questions or concerns? I do want to go ahead and mention that it has been JRG's practice in the past to go ahead and have these webinars monthly. We are reconsidering them, and we do want to continue with having webinars because, first of all, we think they are very educational, they're very informative, and we've been told that they're also very helpful. So you need to be on the lookout for your emails. We'll let you know that when we are having them in 2018. So if we don't have any other questions coming through, we'll go ahead and actually thank you for your participation today. Reminder, if you need that certificate, let us know. And if you need to contact JRG Advisors, here's our phone number, our 1-800 number that you can call. And also, as the Employee Benefits Compliance Officer, I want to go ahead and remind you that we do offer several different compliance services that are available to our clients and actually non-clients, that if you have some compliance concerns and you feel that you would need some assistance that we can help you with, please go ahead and feel free to call us. So thank you again for participating. Our wishes for the best holiday season to you, and we'll see you in the new year. Thank you.